Good morning. Good morning, ladies and gentlemen. So we will now be going to the final assault or to the final discussion or the last discussion of the Philippine Constitution, which is the Part 8. As I told you in the introduction of Part 7, the discussion of Bill of Rights was divided into two. We have the Part 7, which we discussed the sections 1 to 11 of the Bill of Rights, and comes now the Part 8, wherein we are going to discuss sections 12 to 22. My apology, however, because in the PowerPoint presentation of Part 7, ang nakalagay doon ay articles 1 to 11. Dapat sections 1 to 11 yon, because the Bill of Rights is stated under section 3, article 3 of the 1987 Constitution, which is consisted of 22 sections. So what we did is hinati natin ang discussion, because kung hindi natin hatiin yon, the whole discussion of the Bill of Rights may last for about 5 hours. No? So again, we will now be going to sections 12 to 22 of the Bill of Rights. Section 12, Article 3 of the 1987 Constitution is one of the most important provisions of the Constitution as long as the BS Criminology course is concerned, because it enumerates the rights or the constitutional rights of persons under investigation for the commission of an offense, to include the following: the right to be informed of his right to remain silent, the right to have a competent and independent counsel, preferably of his own choice. In this right, we will be discussing some cases in relation to this. The right against torture, force, violence, threat, intimidation, and the like. Let me first clarify uh, a very simple thing, but has a very great effect, that I observed when I ask you to enumerate or to memorize the rights of persons under custodial investigation. Ang na-observe ko lang naman ay, ang iba sa inyo, ang sinasabi nyo ay the right of torture. To tell you, of the words of and against are different from each other. They are opposite, exactly opposite. When we say right against torture, ang ibig sabihin niyan, karapatan laban sa. Ibig sabihin, kailangan na iwasan natin ang torture, force, violence, threat. Okay? Karapatan laban sa ang ibig sabihin ang right against. When you say right of torture, ang ibig sabihin niyan ay karapatan na ma-torture. Okay? So they are exactly opposite with each other. So when we say right against, yan ay karapatan laban sa. When we say right of, that is a right that may be invoked. Kaya kung sasabihin nyo na right of torture, ibig sabihin may karapatan ang mga persons under custodial investigation na sila i-torture, sila i-force. Okay? Yan ang dating nun. So I think that I'm already that I explained that very simple mistake, but I repeat, the consequence of which is very great, no? So in other words, you must know how to use the right of and the right against, no? So to explain some of these rights, we will be going to the case of people of the Philippines versus Patungan. There was a person by the name of Alejandro Patungan. Natagpuan siyang patay sa loob ng kaniyang sasakyan. So investigation was conducted and at nalaman ng pulis na posible ang nagpapatay kay Alejandro ay ang kaniyang asawa mismo, ang kaniyang misis mismo by the name of Marieta Patungan. Kaya si Marieta Patungan ay kinasuhan ng parricide. During the investigation, during the custodial investigation, umamin si Marieta Patungan na siya nga ang nagpapatay sa kaniyang mister. So, but during the custodial investigation, wala siyang abogado. So, after the custodial investigation, there was a written confession, nakasulat ng kanyang pag-amin. At basta ang ginawa ng investigator ay naghanap ng isang abogado sa Integrated Bar of the Philippines. At ang ginawa ng abogado na yan ay basta nag-sign lang siya sa written confession. So as if pinapalabas nila na ang abogado na yan ay inassist niya si Emily Patungan during custodial investigation. But in fact, no assistance was given. Pinapirma lang yung written confession sa abogado na yan after the investigation. So pwede ba yon? Pwede bang gamitin yung written confession laban kay Patungan? According to the Supreme Court, no. Hindi pwedeng gamitin yan. The mere presence and signature of a lawyer is not sufficient compliance with the constitutional requirement of assistance of counsel. So the assistance of counsel must be effective, vigilant, and independent. So another case is in the is entitled People of the Philippines versus Alegria. So almost the same thing. Okay, almost same thing. What happened in the case of Alegria is almost same with the case of Patungan. So there was a security guard that was found dead. Okay, and after an investigation, nalaman nila na ang security guard na yan ay pinatay by means of pananaksak. And after the medical examination, it was revealed that 16 stab wounds were inflicted to the security guard that caused his death. So after the follow-up operation, Dante Alegria and two others were pinpointed as suspects. So they had undergone investigation. So during the investigation, may abogado naman sila. But yung abogado nila, napaka-busy, may ginagawa siyang iba during the investigation. Hindi siya nakikinig sa investigation, no? Ang abogado nila ay may iba siyang ginagawa. So, basta nakaupo lang yung abogado doon, but iba ang kanyang inasikaso, hindi yung investigation in order to protect the rights of Mr. Alegria and two others. So, after the investigation, sabi ng investigator, attorney, tapos na kami. Ito na ang kanyang written confession, umamin na siya at mag-sign lang tayo. So, ang ginawa ni Mr. Alegria at ang kanyang kasama, together with the lawyer, they just affix their signature therein. So, pwede bang gamitin yung written confession laban kay Mr. Alegria and two others? Sabi ng Supreme Court, no na naman. Because the person under investigation for the commission of an offense shall have the right to have a competent and independent counsel. And such counsel, yung abogado, must make a move to ensure that the constitutional rights of that person being investigated are complied with. His mere presence is not sufficient. Hindi sapat ang kanyang presence lang. He must ensure that the constitutional rights of Mr. Alegria are being complied with by the investigator. So, comes now the case of people of the Philippines versus Matos Viduya. So, iba naman ang naging issue dito. Si Matos Viduya ay katulad din ni Patungan, pinapatay niya ang kanyang mister. No? Hindi ko alam kung bakit ganito ang kababaihan. Ano? Pagkatapos silang pagsawahan ang kanyang mister, ay pinagpapatay lang. No? So, abogado pa naman ang mister ni Virginia Viduya. So, pinapatay niya ang kanyang mister. Of course, baka ang tanong niyo sa akin ay, bakit nila kasi pinapapatay ang kanyang mister? Sina Patungan at Matos Viduya. Because they love their boyfriend. Gusto nilang pakasalan ang kanilang boyfriend. So, ganyan lang naman. It is a matter of love life. Love life issue. During the investigation, sabi ni investigator, maghanap muna tayo ng abogado mo bago natin simulan ang investigation. So, nataon, napadaan si Fiskal. At yung Fiskal, kaibigan ni Matos Viduya, yung na-investigate. Kaya sabi ni Matos Viduya, uy, si Fiskal, kaibigan ko yan. Kilalang kilala ko yan. Pwedeng siya na lang ang maging abogado ko. Sabi naman ng investigator, okay, kung kaibigan mo pala si Fiskal, hindi siya na ang maging abogado mo. So, afterwards, umamin si Matos Viduya. Sabi niya, ako, Tito, pinapatay ko ang aking mister kasi gusto kong pakasalan yung aking boyfriend. Mas mahal ko kasi ang aking boyfriend kaysa sa aking mister. So, ang nag-assist sa kanya, Fiskal. So, they signed in the written confession. So, ang issue dito ay, pwede ba yun? Pwede bang Fiskal o prosecutor ang maging abogado ng suspect? Sabi ng Supreme Court, no, hindi pwede. Kasi ang Fiskal, rin-represent nila automatic by virtue of their position, rin-represent nila ang biktima. Kaya hindi nila pwedeng i-represent ang biktima at yung akusado at the same time. So, inulit ko according to the Supreme Court, the Fiscal may not represent the suspect during custodial investigation to satisfy the requirement of the Constitution. This is because by doing so, the Fiscal could not have protected the rights of the suspect. Bakit hindi niya baka hindi niya naproteksyonan ang karapatan ng suspect? Bakit? Dahil ang trabaho ng Fiscal ay sila ang mag-file ng kaso laban sa suspect. Kaya hindi pwedeng sila ang mag-file ng kaso laban sa suspect at the same time sila ang magbigay ng protection sa karapatan ng suspect. No? So, this is in the case of people of the Philippines versus Matos Viduya. So, comes now the case of people of the Philippines versus Barikit. So, this happened at Cebu. May magpipinsan by the name of Pedro, Constituto, basta, 4 ang mga yun, ano? I did not memorize their name. So, may 4 na magpinsan. Nakapatay sila at pinagnakawan nila yung pinatay nila na mag-asawa. So, may mga testigo na nakakita sa ginawa nila. So, pagkatapos ng ginawa yon, yung krimen, tumakas sila. So, a manhunt operation was instituted against them. So, nung sila ay hinuli, ay hindi pala sila hinuli, nung sila ay natagpuan, no? The proper term is, nung sila ay natagpuan, hindi sila hinuli. Basta nakikipagkwentuhan lang ang policeman sa kanila. So, sabi nila sa magpipinsan, okay, punta tayo sa police station. Habang sila ay naglalakad, sila ay nakikipagkwentuhan. So, nung inulit ko, nung sila ay naglalakad papunta sa police station, umamin yung magpinsan. Sabi nila, oo, totoo, kami ang pumatay at pinagnakawan namin yung biktima. So, linagay nila sa record ng policeman na umamin sila habang sila ay naglalakad. So, may abogado ba? Of course, wala. Wala kasi naglalakad pa lang sila papunta sa police station at dyan sila umamin. So, the written confession was used against the Barikit cousins. So, sabi ng policeman, oh, ito ang ebidensya namin, umamin sila. Ito ang affidavit na nagsasabi na umamin sila habang kami naglalakad papunta sa police station. So, sabi naman ng abogado ng during trial na ito, during trial. Sabi ng abogado ng Barikit cousins, dapat may abogado na nag-sign sa written confession na yan. Sabi naman ng mga policeman, bakit pa kami maghahanap ng abogado? Wala namang custodial investigation kung tutuusin. Walang custodial investigation kasi hindi namin sila hinuli, nakikipagkwentuhan lang kami sa kanila. Tapos umamin sila. No? So bakit kami nakikipagkwentuhan? Hindi naman they were not arrested. We were just walking when they were located from the place where they are located up to the police station. So, determining factor ba? Kaya ang napakadaming issues dito, no? Napakadaming issues dito, but ang isang issue dito ay determining factor ba yung place of interrogation? Pwede bang sabihin ng policeman na, ay walang interrogation, walang investigation kasi sa daan ginawa yan hindi sa police station. At nakikipagkwentuhan lang kami. So there is no investigation yet. So sabi ng Supreme Court, mukhang mali yung paniniwala ng policeman. The place of interrogation or investigation is not determinative of the existence or absence of custodial investigation, but the tone and manner of questioning by the police authorities. Kaya hindi determining factor kung saan ginawa yung investigation. Ang determining factor ay nung tinatanong ang Barikit cousins na yan, kinonsider na ba sila na suspect? Kaya kung kinonsider sila na suspect, without regard kung saan ginawa yon, without regard kung hinuli o hindi, there is already custodial investigation. Kaya entitled na sila sa right to counsel. So as I told you, napakadaming issues sa Barikit na ito. So kung hindi ako nagkakamali, babalikan natin ang kaso na ito afterwards, no? So what are the rights that may be claimed anytime during custodial investigation? Ano-ano ba ang mga karapatan na pwedeng i-claim anytime, kahit anong oras during custodial investigation? So first is the right to remain silent. And the second is the right against torture, force, violence. And next is the right not to be held in secret, solitary, incommunicado. And the right to waive any of the right to waive the right to silence, provided that it is done in the presence of a counsel. Okay? So, paano naman yung right to counsel? So, inulit ko itong rights na ito, itong 1, 2, 3, 4 na naka-enumerate na rights, they can be claimed anytime. Paano naman, ang next issue ay, paano naman yung karapatan na magkaroon ng competent and independent counsel? Kailan ba i-claim yun? No? So, i-classify natin. Okay, let's go to the first instance. During invitation by a policeman, and the person is considered as a suspect in the crime committed, okay? So, in-invite yung, kasi kung minsan may kalokohan na ginagawa ng policeman natin Sabi na invitation, no? To shed light, ganon. Afterwards, pag upo ng kaya feeling ng tao na yan, siya lang ay ini-invite as a visitor, ganon. No? Pag upo ng taong yan, ang manner ng pagtatanong pala sa kanya ay kinakonsider siya ng suspect. In this case, that person is entitled to a counsel. No? Kahit na kung ang ginamit na terminology ay invitation lang. Pero kinakonsider siya na suspect, he is entitled to counsel. Paano kung that person was invited by the policeman, pero hindi naman siya kinakonsider na suspect? In that case, that person is not entitled to counsel. No? Let's go to the third instance. During arrest and eventual investigation by the policeman, katulad ng nangyari sa Barikit case, no? But ang palusot ng policeman doon, walang paghuli daw. Paano kung na-locate o nahuli yung offenders, tapos agad-agad ay may investigation, no? At hindi pwedeng gamitin na palusot ng mga policeman na sila ay nakikipagkwentuhan lang. In this case, the person is entitled to counsel, no? So during arrest and an eventual investigation by a policeman, that person is entitled to a counsel. Let's go to the fourth instance. Paano kung sa police lineup? Ang ibig sabihin ng police lineup ay, yun, naka-line lahat ang mga possible suspects, tapos ang gagawin ng testigo o yung biktima ay ipipinpoint niya kung sino sa kanila ang nakita niyang gumawa ng krimen. No? Police lineup ang tawag natin doon. Entitled ba sila ng right to counsel? Yung naka-line up na suspects na yon? To tell you, no, that person is not entitled to counsel. Let's go to fifth instance. During detention and investigation by a policeman. So, in relation to the crime committed, yung tao ay nakadetain, okay, dinetain yung tao na yan, afterwards ay tinawag siya for an investigation. So, he is entitled to counsel. Let's go to number 6. During detention but not investigated by a policeman. Nakakulong lang yung tao na yan, but hindi naman siya ini-investigate. In that case, he is not entitled to counsel. Let's go to number 7. Paano yung pag-conduct ng paraffin test? Alam niyo yung itong paraffin test na ito, noong 1970s hindi na ginagamit sa US. But dito sa Pilipinas, still yan ang ginagamit natin. Ang paraffin test ay kung may issue, kung nagpaputok ng baril ang isang tao o hindi, so lalagyan ng kanyang kamay ng wax, okay, paraffin wax. So kung magkakaroon yan ng blue specks, positive yun, ng nitrates. So ibig sabihin ay nagpaputok siya ng baril. But hindi accurate yan, kaya nga sabi ko sa inyo, noong 1970s pa lang ay hindi na ginagamit ng US ang paraffin test na ito. But in the Philippines, we are still using it. Paano kung mag-undergo ng paraffin test ang isang tao? Okay? In that case, he is not entitled to counsel. Hindi kailangan na may abogado siya. Let's go to number 8 situation. During trial and the accused extrajudicially confessed. Nung trial, tapos yung akusado, umamin siya. Kaya, entitled ba siya ng abogado? To tell you, no. That person is not entitled to counsel. Paano kung during trial, pero umamin yung akusado extrajudicially? Ibig sabihin, hindi sa loob ng court in the presence of the judge. Umamin siya sa labas. No? So, we will be discussing a case in relation to this. So, the person is entitled to counsel. No? This person is entitled to counsel. So, let's go now to the different cases that will explain this. Before going to the different cases, let me remind you, that katulad ng sinabi ko sa part 7, the Bill of Rights is being used against the government. It cannot be used against the private individual. Okay? So that was the settled case in a case that I discussed entitled People of the Philippines versus Marty. and People of the Philippines versus Judge Ruben Aizon. Anong nangyari dito sa kaso ni People of the Philippines versus Ruben Aizon? May empleyado ang PAL sa Baguio, Philippine Airlines. So, siya ang cashier. Okay? Ang empleyado na yan ay siya ang cashier ng PAL. So, as usual, alam niyo naman, ang ginagawa ng cashier, they are collecting payments. But, ang ginawa ng cashier na yon, instead na i-turn over ang kanyang collection sa kanyang boss, ay ginasto niya for his personal benefit. No? Kaya kinasuhan ng cashier na yan ng estafa. But bago kinasuhan ng estafa, nag-conduct ng investigation ang kanyang manager. So, umamin yung cashier. Sabi ng cashier, totoo na may collection ako, but hindi ko tinurn over ang collection ko sa'yo, ginasto ko for my personal benefit. So, sabi ni manager, okay lang, importante umamin ka at ilalagay natin ang inyong pag-amin sa sulat. So, ang tawag natin dyan ay written confession. So, sa written confession na yan, nag-sign si cashier at nag-sign si manager, but walang abogado. Sabi na ngayon ni Judge Aizon, hindi ko pwedeng tanggapin yan, yung written confession na yan. Because nung nag-sign ang cashier at nung nag-conduct ng investigation, walang abogado yung akusado. No? Tama ba si Judge Aizon? Sabi ng Supreme Court, no. No? Sabi ng Supreme Court, basic ang rule natin na ang basic ang rule natin na ang karapatan under the Bill of Rights ay pwedeng gamitin laban sa government lang. Hindi pwedeng gamitin laban sa private individuals. Kaya, palitan natin ang facts. Paano kung kinasuhan kayo ng administrative case, estudyante kayo, tapos may nagsampa ng kaso laban sa'yo? Ang hearing authority ay ang dean. Sabi ng dean, totoo ba ang akusasyon laban sa'yo? In that case, hindi mo pwedeng sabihin sa dean na, uy, ikaw naman din, dapat i-inform mo sa akin ang aking right to remain silent at dapat may abogado ako. Can you claim that against your dean? To tell you no, because your dean is a private individual. He is not representing the government. Pero kung ang nagkakandak ng investigation ay policeman, that is now the time that they are going to comply with the provisions of the Bill of Rights. So, let's go to People of the Philippines versus Usman Hasan. This involves police lineup. Yung this involves a case of murder na kung saan yung testigo na-identify niya ang offender during the police lineup. Sabi ng offender, uy, teka lang, hindi pwedeng gamitin yan laban sa akin. Dahil nung na-identify ako sa police lineup, ay wala akong abogado. Pwede ba yon? Pwede bang sabihin ng offender yon na na-identify ako sa lineup, wala akong abogado, kaya hindi pwedeng gamitin yan laban sa akin? Tulad ng sabi ko sa inyo kanina, if it was identified in a police lineup, hindi kailangan ang abogado doon. No? So that can still be used against that person. So, let's go to the case of People of the Philippines versus Dano. This happened at Zamboanga del Sur. Si Barangay Captain, may nagsabi kay Barangay Captain na may magkapatid na nag-aaway, nagsusuntukan. So baka magpatayan ang mga yon. Kaya alalang-alala si Barangay Captain, pinuntahan niya yung magkapatid na Dano. Nakasalubong niya si Alberto Dano, yung isa sa kapatid. At agad-agad umamin si Alberto kay Barangay Captain. Sabi ni Alberto, Barangay Captain, pasensya na. Dahil sa away namin sa kapatid ko, napatay ko ang aking kapatid. No? So, umamin siya agad-agad kay Barangay Captain. Sabi niya, napatay ko ang aking kapatid. So si barangay captain, gumawa siya ng affidavit na nakasalubong niya si Alberto Dano na agad-agad umamin sa kanya sa pagpatay na yon. So, ang issue ay yung affidavit ni barangay captain, pwede bang gamitin laban kay Alberto Dano? Sabi ng Supreme Court, yes. Ito ang tinatawag natin na spontaneous admission, na agad-agad ay umamin ang offender immediately after committing the crime. In that case, it is admissible. No? So in this case, it is admissible. So the spontaneous statements voluntarily given as for the offender orally admitted killing the victim before the barangay captain is admissible. Bakit? In the first place, si barangay captain hindi siya policeman. And second, tulad ng sabi ko sa inyo, spontaneous admission yon. So, because of this, hindi kailangan na may abogado siya nung siya ay umamin. Pwedeng gamitin yan laban sa kanya. So, comes now the case of people of the Philippines versus Makeda. May isang consultant ng World Bank na nakapag-asawa ng isang Filipina. So they settled at Tuba, Benguet. So diyan sila nag-settle. Ang isa sa mga boys nila, isang kasambahay nila by the name of Makeda, nalaman niya na mayaman ang kanyang boss. Kaya ang ginawa niya sa dating consultant ng World Bank na yan is pinatay niya, no? At pinagnakawan. So Benguet and Baguio during that time was placed into hotspot kasi imaginin mo, consultant ng World Bank pinatay sa Benguet, no? So there was a manhunt operation that was instituted against Mr. Makeda. Nahuli naman siya, no? Nahuli siya at kinasuhan. Nung may kaso na laban sa kanya, yung prosecutor ng Baguio, undergoing ng trial, the trial is already undergoing, nandyan ang trial. Sabi ni prosecutor, Makeda, punta ka nga sa office at mag-usap tayo. So, yun, pumunta si Makeda sa opisina ni prosecutor at ang tanong ni prosecutor ay, Makeda, ano ba talaga? Kasi naguguluhan ako sa trial eh. Kung minsan inamin mo, kung minsan hindi. Ano ba talaga? Ikaw ba ang pumatay kay Mr. Baker, yung dating consultant ng World Bank? Tapos biglang umamin si Makeda. No? Biglang umamin si Makeda. Sabi niya, prosecutor, sa totoo lang, ako ang pumatay doon. So, agad-agad gumawa ng written confession si prosecutor. So, nung nag-resume ang trial, sabi ni prosecutor, Judge, may ebidensya ako. Itong si Mr. Makeda ay umamin sa aking office. So, ito ang kanyang written confession. Nag-sign kaming dalawa, plus yung testigo namin. At ang testigo namin ay yung owner at president ng Baguio Colleges Foundation. So, the issue is, pwede bang tanggapin yung written confession na yun? So, sabi ng Supreme Court, hindi pwedeng tanggapin yan. Kasi still, that is part of investigation. Kaya, dapat may abogado siya. No? So, dapat may abogado siya. So, the rights of persons under investigation for the commission of an offense must still be complied with even if the case is already filed in court. Kaya, yung karapatan ng tao under custodial investigation, kailangan na respetuhin yan kahit na kung naisampa sa court ang kaso na yun. No? So, kailan ba maging admissible ang tinatawag natin na extrajudicial confession? Ang ibig sabihin ng extrajudicial confession ay yung pag-amin na ginawa outside trial. Kailan ba maging admissible ang mga yon? So first, dapat na the admission was voluntarily done. It was done with the assistance of a competent and independent counsel. Kailangan na expressly done, hindi siya implied, at kailangan na nakasulat. No? So these are the requirements for an extrajudicial confession to be admitted in court. So let's go to the case of People of the Philippines versus Larry Mahinay. There was a person, isang kasambahay by the name of Larry Mahinay na natutulog sa construction ng kanyang boss. So si Larry Mahinay nakikipag-inuman sa kanyang mga kaibigan, and the community was surprised kasi kinabukasan ay may natagpo ang 12-year-old na babae na pinatay at tinapon lang malapit sa kanyang sa construction na yon, and it was confirmed na yung babae na yan ay na-rape. So initially hinanap nila si Mahinay not as a suspect but as a possible witness, but nawawala siya. So that created a doubt na baka siya ang gumawa ng krimen kasi bakit siya nawawala, no? And ang policeman nag-apply ng search warrant, sinearch yung room kung saan natutulog si Mahinay, at yun, yung ibang gamit ng babae, yung biktima, nandyan sa kanyang room. Okay? So, ano na ang presumption? Hindi siya na ang gumawa ng krimen. Kasi first, nawawala siya. Second, ang ibang gamit ng babae ay natagpuan sa kanyang room. So, a manhunt operation was instituted. So, he was arrested afterwards. But may aligasyon na umamin si Larry Mahinay pero siya ay binugbog ng mga policeman. Kaya ang kanyang written confession ay hindi ginamit laban sa kanya. Nangangahulugan ba ay na-dismiss ang kaso? Hindi naman. Ang written confession lang ang hindi ginamit laban sa kanya, but may iba pang ebidensya, so still he was convicted. No? So, naging complicated itong kaso ni Larry Mahinay kasi tulad ng sabi ko sa inyo, binugbog daw siya para siya ay umamin. Kaya ang ginawa ng Supreme Court, hindi tinanggap yung written confession. So, the written confession was not admissible because it was obtained in violation of the Constitution. But as I told you a while back, he was still declared guilty because there are some evidence that were still used against him. In this case, the Supreme Court expanded the Miranda rights. Ibig sabihin ay in-expand nila yung nasa Section 12, Article 3 of the Constitution. At tinawag nila ito na Mahinay Doctrine. Kaya kung kayo ay tanungin, what is the expanded Miranda rights? That is the Mahinay Doctrine. Bakit tinawag na Mahinay Doctrine? Because it was decided in a case entitled People of the Philippines versus Larry Mahinay. Let's go to Section 13. This is in relation to right to bail, no? So we will be discussing the right to bail under Section 13 of the Bill of Rights. So what is bail? Before discussing some cases in relation to it, we must first discuss a basic terminology, which is bail. So a bail is a security given for the release of a person in custody of law. In Tagalog, ito ang tinatawag natin na piyansa, no? Na nakasuhan ng isang tao tapos payagan siyang lumaya pagsamantala provided he is going to pay or post for his bail. So there are four forms of bail. We have the corporate surety, we have the property bond, and we have the cash deposit and recognizance. So, when we speak of corporate surety, ito yung binibigyan ng corporation na pinapalaya nilang isang akusado, and kung nasa laya na yung akusado na yan, ay dyan na siya magbabayad sa corporation. When we say property bond, usually this is in the form of land titles, no? Na yung land titles ay iso-surrender sa clerk of court, tapos yung clerk of court ay gagawa siya ng annotation sa likod ng land title na yan ay na-surrender for the purpose of answering the bail of a specific person. Next is cash deposit. Okay, by the term alone, cash. Kaya kung sasabihin ng judge na the bail is 40,000, magbabayad ka ng 40,000 bail. No? Bakit tinawag na deposit? Deposit because bail is really a deposit. Na kung saan, ibibigay mo yan sa court, hahawakan niya ng court. Kung sakaling gumawa ka ng major violation ng inyong bail, ika-confiscate yun at ikaw ay huhulihin. Pero kung nag-comply ka sa lahat ng sinasabi ng court, after the case, mas lalo kung napatunayan na wala kang kasalanan, ibabalik yan sa iyo. No? It is a form of deposit. In recognizance, there is no cash involved, there is no property or corporation involved. What is involved here is only trust. Okay? So, in recognizance, it refers to the release of the defendant in custody of a responsible member of the community who shall guarantee his appearance whenever required by the court. Kaya, pwedeng sabihin ni barangay captain na, Judge, pwedeng palayain mo yan, at kung kailangan mo siya sa hearing o sa court, ako mismo ang magdadala sa kanya. Okay? That is what we call recognizance. Of limited application lang itong recognizance na ito. Okay? So, inulit ko, itong recognizance ay of limited application lang. Applicable lang siya if the offense committed is light, if the offender is minor, or if the offender applies for probation. Let's go now to the case of Almeida versus Villaluz. Ang naging issue dito, si Leonardo Almeida ay nakasuhan ng qualified theft sa Pasig. Sabi ni Judge Villaluz, kung gusto mong lumaya, magbayad ka ng 50,000 na cash deposit. Okay, cash ban. So sabi ni Leonardo Almeida, wala akong cash. Pwede bang mag-avail ako ng ibang forms of bail katulad ng corporate surety, katulad ng cash deposit? Tapos sabi ni Judge, hindi pwede. Cash lang. No? Pwede ba yun? Pwede bang sabihin ni Judge na cash lang? Hindi pwede yung other forms of bail. So, the judge cannot require cash bond only. Okay? The rules of court provides for 4 ways of posting bond. Nandyan yung corporate surety, nandyan yung property bond, at nandyan yung recognizance, no? Na pwedeng pagpilian. Hindi pwedeng sasabihin ni judge na cash lang, no? So, let's go to the case of Adeline White versus John Bugtas. Ang nangyari dito is there was a case of frustrated murder. So may isang tao na nakasuhan ng frustrated murder. So ang kanyang penalty ay 4 years and 2 months to 8 years. Ibig sabihin, 4 years and 2 months ang minimum. At ang maximum ay 8 years. Nung siya ay kinulong, ang taong yan maganda naman ang pinakita niya sa penal institution. Nakipag-cooperate siya sa mga programs ng penal institution. Okay? So, nag-apply siya ng parole. Ang ibig sabihin ng parole ay palalayain ang tao na yan kung pinagsilbihan niya ang minimum ng kanyang term. At inulit ko, ano ang minimum ng kanyang imprisonment? That is 4 years and 2 months. At ano ang maximum? That is 8 years. So malapit na niyang matapos ang minimum. Kaya mag-apply na siya ng parole para siya ay palayain at hindi ko kumpletuhin yung 8 years maximum penalty. Ang ginawa ni judge, okay, nag-apply ka pala ng parole, sige, laya ka na. Okay? So, pwede ba yun? Pwede bang palayain ang isang tao by means of recognizance dahil nag-apply siya ng parole? Sabi ng Supreme Court, hindi pwede yun. No? Balikan natin yung recognizance. Applicable ang recognizance when the offense committed is light, when the offender is minor, or when he applies for probation. Magkaiba ang parole sa probation. Ang probation, pinapalaya ang isang tao in the first place under the supervision of a probation officer. In parole, papalayain ang tao na yan dahil napagsilbihan niya ang minimum ng kanyang term. No? Kaya magkaiba ang parole sa probation. Kaya kung mag-apply ng probation ang isang tao, pwede siyang palayain by means of recognizance. Pero kung nag-apply siya ng parole, hindi siya pwedeng palayain by means of recognizance. No? But by the way, you will be having other discussions in relation to that when you will be having your subject non-institutional correction. So, may isa pang kaso, okay, in relation to bail. And this is De La Carma versus Inage. This happened way back 1970s. May isang tao by the name of mayor ito, okay? Mayor itong akusado na to by the name of Ricardo De La Carma of Misamis Oriental. So kinasuhan siya ng multiple murder and multiple frustrated murder. So ilan ang kanyang napatay? 14 daw ang kanyang napatay. At the same time, ang muntik mamatay, which is basis ng frustrated murder, ay 12. No? 12 na katao. Kaya nung siya ay hinuli, sabi ng court, dahil patong-patong ang kaso mo, no? Multiple murder, 14 counts of murder and 12 counts of frustrated murder, ang inyong piyansa ay 1,195,200. But noong 1970 yan. Kaya ngayon ay ilang milyon na yan. No? So, sabi ng Secretary of Justice, mukhang may mali sa amount ng bail. Dapat 40,000 lang. No? Dapat 40,000 lang. So, sabi ng Supreme Court, pwedeng tama yung opinion ng Secretary of Justice na 40,000 lang ang bail. Yun nga lang, ang nakakatawa dito is, nung pa-decide pa lang ng Supreme Court na sasabihin nila na, okay, pwede ka nang mag-bail ng 40,000 pesos lang, si Mayor Ricardo De La Carma ay tumakas. No? Tumakas siya sa provincial jail. No? At hanggang ngayon ay hindi siya nahanap. No? So, paano makakapagpiyansa ang isang tao na tumakas? No? So, there are 3 classifications of bail kung paano siya ibibigay. May tinatawag tayo na bail as a matter of right, may tinatawag tayo na bail as a matter of discretion, and bail be denied outrightly. When we say bail as a matter of right, ito ay yung karapatan ng isang tao na mapalaya by means of bail. Karapatan niya yon, no? Na siya ay palayain by means of bail. So, Bail as a matter of right before or after conviction in the first level courts. Ang tinutukoy ko na first level courts ay yung Metropolitan Trial Court, Municipal Trial Court, Municipal Trial Court in cities, and Municipal Circuit Trial Court. And before conviction in the Regional Trial Court of an offense na hindi punishable ng death, hindi punishable ng reclusion perpetua, at hindi punishable ng life imprisonment. No? So there are two instances when is bail a matter of right. Before or after conviction in the first level courts, and before conviction sa regional trial court na ang imposable penalty ay hindi death, hindi reclusion perpetua, o hindi life imprisonment. Paano naman yung bail as a matter of discretion? Ibig sabihin ay pag-iisipan ng court kung palalayain niya ang tao na yan. So, yan ang tinatawag natin na bail as a matter of discretion. So, kailan ba pag-iisipan ng court kung palalayain niya ang tao na yan by means of bail? That is, upon conviction or after conviction by the regional trial court of an offense not punishable by death, reclusion perpetua, or life imprisonment. Kaya before conviction, a matter of right yan. But after conviction, at nasa appeal ang kanyang kaso, so pag-iisipan ng court kung ibibigay o hindi ibibigay ang bail na yan. So, next is, when is bail be denied outrightly? Ibig sabihin, agad-agad ay i-deny na yan. Hindi siya a matter of right, and that is when that bail is not a matter of right and not a matter of discretion. No, so that bail will be denied outrightly. So, ano-ano ang limitations ng right to bail? Ibig sabihin, ang mga tao na to ay pwede silang palayain by means of bail. O ano ang requirements? First, the person claiming the right to bail must be under actual detention. Kaya na nga yung case ni Mayor de la Carma, hindi na pwedeng palayain yan by means of bail dahil tumakas siya. Dapat ang mag-bail ay yung nasa actual detention, no? O pwede naman na hindi actual detention, basta kung huhuliin na siya, okay, pwede na siyang mag-file ng bail kagad, no? And next is, the right to bail is available only in criminal cases at hindi siya applicable sa deportation proceedings, no? So, balikan natin yung kaso ni Harvey versus Miriam Defensor Santiago. Kasi na-discuss natin ito in part 7 in relation sa warrant of arrest. Diba? Kasi ang discussion natin dyan ay hindi lang yung judge ang pwedeng mag-issue ng warrant of arrest. Pati yung head ng Commission on Immigration and Deportation, pwede din siyang mag-issue ng order of arrest. At ang kanyang huhuliin o ipapahuli ay yung unwanted aliens. No? So, that is in relation to part 7. Ngayon na part 8, ang issue naman na isettle natin sa Harvey versus Miriam Defensor Santiago is in relation naman sa bail. Kasi di ba, naalala nyo yung discussion natin dito? May dalawang foreigners, American citizens ama ito, by the name of Harvey and Sherman. Pumunta sila sa Laguna, nagsettle sila doon, at sila pala ay pedophiles. At mahilig sila sa mga bata at kapwa lalaki, no? So si Miriam Defensor Santiago nag-issue siya ay inutusan niya ang kanyang mga tauhan na mag-conduct ng investigation kung totoo ba ang chismis laban kina Harvey and Sherman. So upon the submission ng report, ang tawag natin dyan ay after mission report, nakita ni Miriam Defensor Santiago na totoo. May mga pictures na sina Harvey at Sherman ay kasama nila ang mga lalaki naked sa loob ng room. Tapos may mga pictures na under the possession ni na Harvey at Sherman, na ang pictures na yan ay mga pictures ng nakahubad na lalaki, no? So pinapakita nila na they are involved in child sex and prostitution. Dahil doon, pinahuli ni Miriam Defensor Santiago ang dalawang ito. Legal ba ang kanilang paghuli? Yes, because under the rules in relation to Commission on Immigration and Deportation, pwedeng mag-issue ng warrant of arrest ang commissioner, no? In order to arrest unwanted aliens. Okay? So, ang second issue dito is, pwede ba silang mag-file ng bail? Kasi sila ay kinulong at nag-a-undergo ng deportation proceeding. Sina Harvey at Sherman ay kinulong at nag-a-undergo ng deportation proceeding. So, ang tanong ay, pwede ba silang lumaya by means of bail? So, sabi ni Miriam Defensor Santiago, hindi pwede because tulad ng sabi natin, the right to bail is available only in criminal cases, hindi sa deportation proceedings. Ano ang sabi ng Supreme Court? Yes. Tama si Miriam Defensor Santiago. It is a rule that the persons undergoing deportation proceedings are not entitled to bail. Aside from this, their continued detention may be justified the fact that they are undesirable aliens even if they did not commit crimes in the Philippines. To tell you, pedophilia is not a crime, but it is a sexual abnormality. And because it is a sexual abnormality, then it is a basis for them to be declared as unwanted alien. So, let's go to the case of United States versus Judge Urugan and Mark Jimenez. So, ang totoong si Mark Jimenez, ang kanyang totoong pangalan ay Mario Batacan Crespo. And to tell you, nanalo pa siya as a congressman, no? Tumakbo siya na congressman, but yun nga lang, meron siyang kaso sa US. So, ang nangyari doon is, dati siya naka-reside sa US. Nakasuhan siya doon, tapos tumakas, pumunta siya dito sa Pilipinas at nanalo pang congressman. So, ano-ano ang kanyang kaso sa US? Tax evasion, illegal campaign contributions, and others. So, nung nasa Pilipinas siya at nanalo pa siyang congressman, ang DOJ ng US, sinulatan nila ang DOJ ng Pilipinas. So sabi ng DOJ ng US, yang si Batacan Crespo, alias Mark Jimenez, madami siyang kaso dito. Pwede bang huliin ninyo at dalhin nyo dito at padala nyo dito sa US under the extradition treaty? So yan ang ginawa ng Pilipinas. Hinuli nila si Mark Jimenez, tapos pinadala sa US. Bago dadalhin sa US si Mark Jimenez, siya ay dinetain muna dito sa Pilipinas. Sabi ni Mark Jimenez, pwede ba akong mag-apply ng bail dito sa Pilipinas? Kasi sa US, bailable naman yan eh. Okay? If I will be going to US, bailable din yan. Kaya pwede ba akong mag-apply ng bail dito sa Pilipinas for my temporary release bago ako pupunta sa US? Sabi ng Supreme Court, no, because it is a deportation proceedings and he is may possibility of flight. Ibig sabihin, may possibility na tatakas daw si Mark Jimenez. Dahil doon ay hindi siya pinagbigyan na lumaya by means of bail. Iba naman, itong kaso ni Government of Hong Kong versus Eulalia. So, what happened in this case is, may isang tao by the name of Munoz, okay? Juan Antonio Munoz, na kinasuhan sa Hong Kong. May kaso siya sa Hong Kong. Tapos katulad ng ginawa ni Jimenez, from Hong Kong, pumunta siya dito sa Pilipinas. At tulad din ng nangyari kay Jimenez, ang DOJ ng Hong Kong, may extradition treaty tayo sa Hong Kong. Yung DOJ ng Hong Kong, sinulatan niya ang DOJ ng Pilipinas. Sabi ng DOJ of Hong Kong, pwede bang huliin niyo ang Munoz na yan at i-extradite ninyo dito sa Hong Kong o dadalhin niyo dito sa Hong Kong. So, pinagbigyan, katulad ng ginawa kay Jimenez. Hinuli si Munoz at dinetain dito pending yung pag-transfer niya sa Hong Kong. So, nag-apply si Munoz ng bail for him to be released pending ng pagkuha ng Hong Kong government sa kanya. So, kakaiba ito kasi pinagbigyan ng Supreme Court. Sabi ng Supreme Court, okay, it is an extradition proceeding, but sa tingin naman namin ay hindi ka flight risk. Hindi ka naman tatakas. Hindi ka tulad ni Batacan Crespo. No? Sa tingin naman namin ay hindi ka tatakas, kaya sige, pwede ka nang lumaya by means of bail. No? So, anong pagkakaiba ng Eulalia case versus Mark Jimenez case? Si Mark Jimenez, flight risk daw siya. Pwede siyang natatakot ang government na baka tumakas siya kaya hindi siya pinagbigyan na mag-bail. But in the case of Eulalia, ang involved na tao dito ay na-convince ang court na hindi siya tatakas kaya pinagbigyan siya na mag-bail. So let's go to Section 14. Another complicated provision of the Bill of Rights is Section 14. Baka ang tanong nyo sa akin, anong pagkakaiba ng Section 12 sa Section 14? Ang Section 12, yan ay yung karapatan ng tao under investigation ng policeman, okay, for the commission of an offense. Samantalang itong Section 14, ito yung karapatan ng akusado kung meron na siyang kaso na criminal case sa court. Okay? Ano ang kanyang karapatan? So magkaiba to, no? So inulit ko, Section 12, this refers to the rights of persons under investigation for the commission of an offense. Section 14, ito naman yung rights of persons during trial or rights of the accused during trial in a criminal case. So, madami yan. No? If you are going to read the provisions, madami yan. No? So, we will be explaining them one by one. So, let's go to the order of trial. Under the order of trial, ang maunang magbigay ng ebidensya ay yung prosecution, yung biktima. Pagkatapos magbigay ng biktima ng kaniyang ebidensya, it will now be the accused. Tapos yung biktima na naman, tapos yung accused, no? But only one thing is certain. Yung biktima ang first na magbigay ng ebidensya. Pwede bang mauna ang akusado na magbigay ng ebidensya? Yes. Pwedeng mauna ang akusado na magbigay ng ebidensya if the accused will be claiming an affirmative defense like self-defense. Kaya inulit ko, kung ang akusado ay i-claim niya ang affirmative defense katulad ng self-defense, siya na ngayon ang maunang magbigay ng ebidensya to prove yung self-defense na yon, followed by the prosecution. No? So, to explain that, is we have the case of Sakay versus Sandigan Bayan. This involves a patrolman, policeman. Kinasuhan siya ng two separate crimes of homicide dahil nakapatay daw siya. So, ang kanyang depensa, self-defense. So, sabi ng court, okay, dahil self-defense ang depensa mo, sinasabi mo na pinagtanggol mo ang inyong sarili, ito ang gawin natin. Policeman Sakay, ikaw na ngayon ang unang magbigay ng inyong ebidensya. Patunayan mo na may self-defense. Kung hindi mo napatunayan na may self-defense, automatic guilty ka, no? Kaya ang outcome ng kaso na ito ay depende kung napatunayan mo na ikaw ay na self-defense 'yon. So depende na sa result ng inyong pagpapatunay ng self-defense. So I repeat, if you prove that that is really self-defense, you are not guilty. But if you did not prove, automatic, you are guilty. Okay? Yan ang sabi ng judge sa kanya. Tama ba yun? Tama ba yun? Okay, i-classify natin. The court was correct in reversing the order of trial. Tama yung decision ng court na i-reverse ang order of trial, na yung akusado ang first na magbigay ng ebidensya, no? Because he claimed self-defense. Pero mali yung court nung sinabi niya na automatic ay guilty si Policeman Sakay kung hindi napatunayan ang self-defense. Still, we must comply yung tinatawag natin na presumption of innocence. Hayaan natin ang prosecution na sila ang magbigay ng ebidensya laban sa kanya, no? So, let's go to the rights of the accused in criminal prosecution. So, we have the right to be presumed innocent. Kaya sa kaso ni Sakay, this is violated, no? Kasi automatic ang tingin ng court na sa kanya ay siya ay guilty, no? So, right to be heard by himself and counsel, right to be informed of the nature and accusation of the cause of the accusation against him, so on and so forth. Basahin nyo lang ang mga yan, no? So, let's go to trial in absentia. When can we say that there is a trial in absentia? So, trial in absentia means that the trial may proceed kahit na kung wala yung akusado. Kailan ba natin masasabi na valid yun? Okay? So, these are the requisites of trial in absentia. First, the accused was duly arraigned. Ibig sabihin, natanong si akusado kung ano bang inyong plea, guilty or not guilty. Tapos ang kanyang plea, not guilty. No? Arraignment ang tawag natin doon. He was duly arraigned. Next, the accused was notified of the hearing. Nasabihan siya na may hearing. And the accused absence during trial is unjustifiable. Yan ang tinatawag natin na trial in absentia. So, do not forget that the first requirement is kailangan na may arraignment. Kailangan na natanong yung akusado kung ano bang inyong plea, if guilty or not guilty. So, let's go to the case of People of the Philippines versus Judge Salas. There was a crime of murder that was filed against Rodolfo Valdez. Okay? May kaso ng murder. Sabi ni judge, okay, pwede kang lumaya, magbayad ka lang ng 30,000 pesos. No? Magbayad ka lang ng 30,000 pesos. So yan ang ginawa ni Rodolfo. Okay? Lumaya siya, nagbayad siya ng 30,000 pesos na piyansa or bail. So, ang naging issue dito ay, paano na yan? Lumaya yung akusado. Tapos sabi ng akusado, I am now waiving my right of appearance. No? I am now waiving my right of appearance. Na, sige, gawin nyo lang ang gusto nyo gawin nyo dyan sa court kahit hindi na ako mag-appear. No? Pwede ba yon? To tell you, pwede yon. Provided, no? Pwede yon. Provided may arraignment, provided nasabihan yung, balik tayo sa basic, provided na-arraign yung akusado, provided siya ay na-notify na may hearing, and provided ay hindi siya sumipot unjustifiably. No? So, paano na ngayon kung may testigo at sinasabi nila na si Rodolfo Valdez ang nakita nilang gumawa ng krimen. In that case, waive na ang identification. Ibig sabihin, kung sinasabi nilang akusado, automatic si Valdez na yon. So I repeat, generally, an accused may waive his right to appear before the trial. But during arraignment, promulgation of decision and identification of witnesses, kailangan na nandyan siya. Ano ang mga situation na kung saan kailangan na nandiyan ang akusado sa trial? During arraignment, promulgation of decision, and identification. Paano kung during trial ay wala siya, considering the fact that he was informed? Okay? In that case, he is deemed to have waived yung identification. Kaya kung sinabi ng testigo na yung akusado, automatic siya na yun. Siya na ang tinutukoy. No? So, let's go to the case of people of the Philippines versus Holgado. No? Si Frisco Holgado ay kinasuhan ng slight illegal detention. Ang nakakatawa dito, after the arraignment at hearing na, ang tanong ni judge sa kanya ay, akusado, Mr. Frisco Holgado, do you have an attorney or are you going to plead guilty? I'm very sorry. Arraignment pala ito. Sa arraignment pala ito. During the arraignment, yan ang tinanong ni judge. May abogado ka ba o aamin ka na lang? So, sabi ni Frisco Holgado, wala po akong abogado, judge. Aminin ko na lang. No? I will enter the plea of guilty. So, tama ba yung arraignment at trial, no, na ginawa ni judge? To tell you no, hindi proper yun. No? Dapat, kung wala siyang abogado, bigyan siya ng abogado, no, for his rights in trial to be protected. Let's go to the case of people of the Philippines versus Crisologo. Arraignment na naman to, no? This involves arraignment and trial na naman. Si Susimo Crisologo, alias Amang, ay deaf-mute. Ibig sabihin ng deaf-mute ay siya ay bingi at hindi makapag-salita, no? Deaf-mute. So, kailangan na makipag-communicate sa kanya by means of sign language. Kinasuhan siya ng robbery with homicide that was committed way back 1976. So, noong 1976, hindi pa masyado yung sign language. Ang ginawa ni judge, dahil kahit na kung basahin naman, common sense naman, kahit na kung basahin yung information o yung complaint laban kay Crisologo, paano niya madidinig yan? Deaf-mute na nga siya. It happened na my best friend, si Susimo Crisologo, nung bata pa siya, by the name of Munoz, na nag-interpret sa kanya sa provisions ng information na yan through sign language ay in-interpret ng kanyang best friend. So, nag-object ang abogado ni Susimo Crisologo. Sabi ng kanyang abogado, teka lang, mukhang may mali sa arraignment. Ulitin natin ang arraignment. Dapat na may expert in sign language na mag-interpret kay Susimo Crisologo sa contents ng information na yan. Ang naging problema doon, nakasuhan siya noong 1976, noong 1983, wala pang dumating na expert in sign language. So, ibig sabihin, na-detain siya ng 77, 78, 79, 80, 81, 82, 83. 7 years already lapsed na wala pang expert ng sign language. Kaya sabi ng abogado ni Susimo Crisologo, i-waive na lang natin yan. Kahit baliwalain na lang natin ang reading of, anong tawag dito? reading of information. So, after the arraignment, yun, nagkaroon na ng trial. So, during trial, walang expert in sign language na mag-inform kay Sosimo Crisologo kung ano ang updates sa kanyang trial. Basta tahimik lang siya doon kasi wala siyang nadidinig. Bingi siya eh. No? So, after the trial, ang decision ni judge, guilty. No? Guilty. So, the lawyer questioned, sabi ng abogado, mukhang may mali ah. He was not given the opportunity to be heard because considering the fact that he was not represented by a expert in sign language during trial. Ano ang sabi ng Supreme Court? Yes, tama ang kanyang abogado. The non-employment of a sign language expert is fatal in the validity of the proceedings because the accused was denied of his right to be informed of the nature and the cause of accusation against him. Dahil doon, ang entire proceeding ay considered null and void. Walang silbi. Kaya uulitin ulit. No? Yung hearing. So, let's go to the case of people of the Philippines versus versus Cineris. This involves na naman ng isang misis na pinapatay ang kanyang mister. No? Hindi ko alam kung bakit uso ang kaso na ito. Yung misis, gusto niyang makatuluyan ang kanyang boyfriend, kaya pinapatay niya ang kanyang mister. So, kinasuhan ang misis na yan by the name of Pilar Angeles. Kinasuhan siya ng parricide dahil pinapatay niya ang kanyang mister. May binayaran siya na pumatay sa kanyang mister. So, ang kanyang binayaran ay has a name of Mario Nemencio. Nahuli si Mario Nemencio, kamanas ni Angeles at ang kanyang na-hire, napapatay sa kanyang mister ay nahuli. So, umamin agad-agad si Nemencio. Sabi ni Nemencio, totoo, ako ang pumatay kay ako ang pumatay sa mister ni Angeles. So, natapos na yung kaso laban sa kanya, no? So, dalawang nakasuhan dito. Si Angeles ay nakasuhan ng parricide, tapos si Nemencio naman ay nakasuhan ng murder. Agad-agad ay natapos ang kaso ni Nemencio. So, siya ay nasa kulungan. Ang parricide case naman ni Pilar Angeles, yan na ang dinidinig sa court. Walang ibang testigo na pwedeng i-present ng prosecution. Kaya ang ginawa ng prosecution ay kinausap nila si Nemencio na kung pwede ay siya ang mag-testify laban kay Pilar Angeles. Pumayag naman si Nemencio. So sabi ni Nemencio, okay, ako na mag-testify laban kay Pilar Angeles. So yun. So during the direct examination, ang direct examination ay yan ay examination na ginagawa ng party na tumawag sa kanya. Kaya prosecution ang prosecution ang nag-avail kay Nemencio para siya ay maging witness. Kaya nung siya ay tinatanong ng prosecution, direct examination ang tawag doon. Kung tatanungin naman siya ng depensa, cross-examination ang tawag doon. Natapos ang direct examination. Ang cross-examination, partial lang. Tapos sabi ni judge, oops, teka lang. Ang cross-examination, ituloy na lang natin next hearing. Yun nga lang, bago dumating ang next hearing, si Nemencio ay napatay. Okay? Binaril siya sa bilangguan dahil tinangka daw niyang tumakas. So, ang issue dito ay, pwede bang tanggapin ang testigo ni Nemencio laban kay laban kay Pilar Angeles? Sabi ng Supreme Court, yes. Pwedeng tanggapin provided na napag-usapan yan during the cross-examination. Yung hindi napag-usapan during cross-examination, pasensya na, hindi pwedeng gamitin laban kay Pilar Angeles. No? So, let's go to the case of Fajardo versus Garcia. So, ang issue naman dito is ganito 'yon. May mga kinasuhan ng murder. So, tatlo, kung hindi ako nagkakamali, tatlong katao 'yon, kinasuhan ng murder. So, bago kasi i-detain ang isang suspect, dapat na mag-undergo yan ng medical examination. Mandatory yun. No? Kaya kung may nahuling suspect, bago i-detain, kailangan na mag-undergo ng medical examination. Yung tatlong suspect na ito, nag-undergo sila ng medical examination under Dr. Academia. Kaya ang nag-conduct ng kanilang medical examination ay si Dr. Academia. So, ang isa sa mga findings ay yung mga suspect, bago sila dinetain, ay may mga sugat sila. Kaya nakalagay doon ang findings ng medical examination. Si Dr. Academia ngayon ay pumunta siya sa US. During the trial ng murder ng mga Fajardo, nalaman ng akusado na kailangan nila ang testimonya ni Dr. Academia na nag-conduct ng medical examination sa kanila. Kaya sabi ng akusado ay dapat i-invite natin si Dr. Academia at siya ang mag-testify kung ano ang medical examination na ginawa niya sa amin. Yun nga ang problema nga doon, si Dr. Academia nasa US na. Nasa United States na siya. Pwede bang papuntahin yung nasa United States? Pwede ba siyang i-invite at pupunta siya dito sa Pilipinas only to explain kung ano ang nakalagay sa kanyang medical examination? Sabi ng Supreme Court, no. Such witness who is already residing abroad is beyond the jurisdiction of the Philippine courts. Wala nang jurisdiction ang courts ng Philippines sa kanila. Tapos kung tutuusin, sabi ng Supreme Court, yung medical examination, nandyan lang naman yan eh. Kahit sinong medical doctor, pwede nilang i-explain yan. Hindi si Dr. Academia lang. No? So, let's go to yung tinatawag natin na Equipoise Rule. Sa criminal procedure, may tinatawag tayo na Equipoise Rule. This states that if the evidence in a criminal case is evenly balanced, the constitutional presumption of innocence tilts to the scale of justice in favor of the accused. Okay, di ba? Kung ano-anong terminology na ginamit in defining this Equipoise Rule, but simple lang naman ang ibig sabihin nito. Paano kung pagkatapos ng trial ay evenly balanced ang ebidensya? Sa tingin ng court ay 50% siya ay guilty, 50% hindi din siya guilty. Di ba? 50-50, equipoise. No? So, ano na ang sabi ng batas natin sa Equipoise Rule? I-consider siya na innocent. Kasi ang presumption, siya ay innocent. No? Kaya inulit ka, paano kung pagkatapos ng trial, 50-50 ang assessment ni judge. Sabi ni judge, mukhang 50% guilty siya. Pero mukhang 50% hindi din siya guilty. Ano ang sundin natin? Hindi na siya guilty because of the presumption of innocence. Let's go now to the case of Malana versus people of the Philippines. Si Dominador Malana ay kinasuhan ng multiple frustrated murder. So, I repeat, si Malana ay kinasuhan ng multiple frustrated murder. Napakadaming ebidensya na lumabas laban sa kanya. Katulad ng eyewitnesses na nakakita kung paano ginawa ang krimen. So, may mga ebidensya pa, physical evidence against sa kanya. So, dahil madaming ebidensya laban sa kanya, after the trial, sabi ni judge, dahil madaming ebidensya laban sa iyo, Malana, guilty ka. Ang naging problema dito, biglang sabi ni Malana, ay paano naman yung Equipoise Rule? Under the Equipoise Rule is kung 50-50, 50% ang sa assessment ni judge ay 50% guilty at 50% innocent, ay i-apply natin yung presumption of innocence. Wala akong kasalanan. So, ang issue dito ay, i-apply ba natin ang Equipoise Rule sa kaso ni Malana? Sabi ng Supreme Court, no. The Equipoise Rule cannot be applied when the evidence presented by the prosecution is overwhelming. Kung napakalakas masyado ang present ng prosecution at walang ebidensya na present ng depensa, hindi natin pwedeng i-apply yung Equipoise Rule doon. No? That is in the case of people of the Malana versus people of the Philippines. Let's go to our, Section 15, Article 3 of the Constitution in relation to the writ of habeas corpus. Hindi pwedeng isuspend ito maliban kung may invasion or rebellion when public safety requires it. So, ano ba ang habeas corpus? Literally, ang ibig sabihin ng habeas corpus ay you have the body. Ano ang purpose ng writ or petition of habeas corpus na ito? Ito ay kinocommand ang isang individual o government official na may jurisdiction sa nakadetain na tao na i-present yan sa court. Kaya kung sakaling sasabihin ng judge na, oy, Chief of Police, Mr. Chief of Police Captain A, pakita mo sa akin ang tao na yan. Yon, habeas corpus yun. Kaya ang gagawin ni Chief of Police, kukunin niya ang tao under sa kanyang detention at ipapakita niya kay judge. Ano ang purpose ng habeas corpus? Of course, ang hindi natin maitanggi na purpose niyan ay para patunayan na buhay pa ang taong yun. No? And second is, aalamin ni judge kung naaayon ba sa batas ang pag-detain sa taong yan. Kung naaayon sa batas, hindi ituloy ang pag-detain sa taong yan. Pero kung hindi naayon sa batas, siya na ngayon ay palayain. No? That is writ of habeas corpus. So, let's go to Section 16, Article 3 of the 1987 Constitution, which states that all persons shall have the right to speedy disposition of their cases. So, ito yung tinatawag natin na right to a speedy disposition of cases. Okay? To explain this, we have Jaime Bernat versus Sandigan Bayan. Anong nangyari dito? What happened in this case? Noong 1994, na-isubmit na for decision ang kaso ni Jaime Bernat. Okay? That is violation of Republic Act 3019. The Anti-Graft and Corrupt Practices Act. So inulit ko, noong 1994, submitted for decision na yon. Ibig sabihin, tapos na ang trial. It is already submitted for decision. But no decision was made. Noong 1997, kamalas ni Jaime Bernat na ito, na-reorganize ang Sandigan Bayan. At ang kaso niya napunta sa ibang justice ng Sandigan Bayan noong 1997. Noong 2002, okay, wala pang decision ang Sandigan Bayan sa kanyang kaso. Considering the fact na submitted for decision siya noong 1994. 8 years already lapsed. Okay? After 8 years, sabi ni Jaime Bernat, i-dismiss nyo na ang kaso ko because you violated my right to a speedy disposition of cases. So, ito na nga masaklap eh. Common sense, kung common sense ang gagamitin natin, ay talagang may violation of speedy disposition of cases. Di ba? Kasi imagine mo naman, 8 years, wala pang decision. Pero sabi ng Supreme Court, no, there is no violation. No, there is no violation. Because si Jaime Bernat, hindi niya clean name ang kanyang karapatan ng mas maaga. Dapat mas maaga na sinabi ni Jaime Bernat na na-violate ang kanyang right to speedy disposition para ma-dismiss ang kanyang kaso. Eh, hinintay niya ang 8 years bago niya i-claim yon. Kaya sabi ng Supreme Court, there is no violation of right to speedy disposition of cases. So, let's go to Section 17 of the Constitution, which states that no person shall be compelled to be a witness against himself. Walang tao na pwedeng pilitin na maging testigo laban sa kanyang sarili. No? So this is known as the right against self-incrimination. No? So Section 17 is known as the right against self-incrimination. So to explain this case, we have the Chavez versus we have the case of Chavez versus Court of Appeals. CA means Court of Appeals. What happened in this case? Si Chavez at tatlong iba pa nakasuhan ng qualified theft. Inulit ko si Chavez at tatlong iba pa nakasuhan ng qualified theft. Walang ebidensya na na-i-present laban sa kanila. Tapos sabi ni fiscal at ni judge, eh paano Chavez kung umamin ka na lang? Ikwento mo kung paano nyo ginawa ang krimen, gano'n. Umamin ka na lang. No? Sabi ng abogado ni Chavez, anong tingin nyo sa kliyente ko? Tanga? Eh kung aamin siya, edi may incriminate pa siya sa kaso na yan. And take note, napakalinaw sa ating saligang batas na hindi pwedeng pilitin ang isang tao na mag-testify laban sa kanya. Sabi naman ng fiscal at yung judge, ay nako, huwag kayong mag-alala kasi kwento-kwentuhan lang naman to. Kwento-kwentuhan lang naman to na ikaw, Chavez, baka may gusto kang ikwento dyan na hindi namin alam. At huwag kang mag-alala, hindi namin gagamitin yan laban sa iyo, Chavez. Okay? Kaya naging kampante na si Chavez at ang kanyang abogado. No? Na, ay, kwento-kwentuhan lang pala to eh. Okay? So sabi ni Chavez, oo, totoo, ginawa ko ang krimen. Kasama ko yung tatlong iba dyan. Pagkatapos nagkwento si Chavez, agad-agad, nag-issue ng decision si judge. Sabi ni judge, kayong tatlo na iba pang akusado, acquitted na kayo. Pero ikaw, Chavez, guilty ka. No? Guilty ka. Eh, nadinig naman natin lahat. No? Nadinig naman natin lahat kung ano ang inyong testimonya na umamin ka na kayo ang gumawa ng krimen. Ayun. Tama ba yun? Tama ba yun? Ibig sabihin, naisahan nila si Chavez. No? Ibig sabihin na naisahan nila. Tama ba yun? Sabi ng Supreme Court, no. The act of the court authorizing Chavez to become a witness against himself is not proper. By the act of the court, it forced Chavez to testify against himself. Yun nga, naisahan nila si Chavez na hindi pwede yun. No? So, according to the Supreme Court, the proceeding in this case shall be considered null and void. Walang silbi. Kailangan na ulitin. So, let's go now to the case of right against self-incrimination. Kailan ba hindi ma-claim itong tinatawag natin na right against self-incrimination? Okay? First, by forcing a woman to give sample of urine to determine kung siya ay pregnant o hindi. Pwede bang pilitin ang babae na magbigay ng kanyang sample urine? Yes. Hindi pwedeng sabihin ng babae na, oh, do not violate my right against self-incrimination. There is no right of self-incrimination in these 4 cases because they are not required to talk. The right against self-incrimination can be claimed only if they are required to talk. Di ba? Eh, kung magbigay lang naman ng sample ng urine, you're not required to talk there. Next is determining whether the person is suffering from sexually transmitted disease. Next is determining whether the person is under influence of prohibited drugs. Kasi hindi naman kailangan na magsalita yun. Pwede kumuha lang sila ng sample ng kanyang saliva and others. And next is forcing a person to try a pair of shoes, pants, or shirts. Paano kung sasabihin sa akusado na, oh, suot mo nga ang pants na yan kung kasya yan sa'yo. Suot mo nga yan kung kasya sa'yo. So, pwede bang siyang pilitin? Yes, because he is not required to talk. No? Kaya hindi pwedeng gamitin ang right against self-incrimination in these instances. But, may kakaibang instance. How about kung magbigay ng sample ng handwriting? Ang isang tao, pwede ba siyang pilitin na magbigay ng sample ng kanyang handwriting? So, sabi ng Supreme Court, though the act of giving sample handwriting does not require testimonial compulsion, hindi naman siya pipilitin na magsalita. The right against self-incrimination will be violated kung pipilitin. Kaya huwag pilitin ang isang tao na magbigay ng sample ng kanyang handwriting. Covered yan ng right against self-incrimination. Bakit? Because it involves intelligence of a person. No? Yung pagsulat it involves intelligence of a person, katulad ng pagsasalita. So, it is covered by the right against self-incrimination. Let's go to Section 18, Article 3 of the Constitution. So, it involves the right against detention solely by reason of political beliefs and aspirations, and right against involuntary servitude. Ibig sabihin ay pwede tayong maniwala kahit na kung anong gusto nating paniwalaan ng pampolitikal, and tayo din ay hindi pwedeng masubject sa involuntary servitude. Ang ibig sabihin ng involuntary servitude ay pipilitin ka na gawin ang isang bagay na ayaw mo. No? So, comes now the case of Aclaracion versus Gatmaitan. Si Aclaracion ay stenographer sa Nueva Ecija. Alam niyo ba ang trabaho ng stenographer? Sila yung kung may proceeding, kakaibang sulat ng may ito. No? So, may mga, basta silang nagtitake down notes, okay, sa mga proceedings. Pero hindi, yung pag-take down notes nila is not yung ordinary handwriting. No? May kakaiba silang sulat. No? So, for you to become a stenographer, you will be undergoing a training for that purpose. No? Nung naging stenographer si Aclaracion, hindi niya na-transcribe ang ibang stenographic notes. Kaya stenographic notes ang tawag doon. Hindi niya na ilalagay sa ordinary na sulat. Basta naka-stenographic notes lang siya. Kung titignan niyo ang stenographic notes, mukha siya lang siyang drawing na sila lang ang nakakaintindi. Hindi niya na ilipat yon sa ordinary words, no? At nag-resign siya. So, sabi ng court, ikaw, Aclaracion, kahit na kung nag-resign ka, kailangan na i-transcribe mo yung stenographic notes na yon. Ilagay mo siya sa ordinary words na naintindihan namin. Tapos ayaw ni Aclaracion. Sabi ni Aclaracion, how about my right against involuntary servitude? Pinipilit nyo naman ako na gawin ang isang bagay na ayaw kong gawin. No? Pwede bang sabihin ni Aclaracion yon? Hindi niya pwedeng sabihin yon. Kasi bago siya nag-resign, obligasyon niya na gawin yon at nakuha na niya ang sweldo niya doon. No? Kaya pwede siyang pilitin na i-transcribe ang kanyang stenographic notes. No? So, let's go to Section 19, Article 3 of the 1987 Constitution. That is the right against excessive fines, cruel, degrading, or unusual penalties. Ibig sabihin ng excessive fines ay sobra-sobrang fines, o ibig sabihin ng cruel, degrading, or unusual penalties ay ito yung mga penalties na hindi makatao. No? So, what are the prohibitions under the Constitution? Ang pinagbabawal, yung excessive fines, yung labis-labis na fines. Next is yung cruel, degrading, inhuman punishment, yung hindi makatao na punishment. And next is death penalty. I-discuss natin kung ano bang nangyari sa death penalty by virtue of the 1987 Constitution. And next is the right against double jeopardy. No? So medyo malawak ang discussions natin dito. So let's go to the case of Echegaray versus Leo Echegaray versus Secretary of Justice. Si Leo Echegaray ay nakasuhan ng rape. So ni-rape daw niya ang kanyang stepdaughter way back 1994. So ang penalty na binigay sa kanya is death penalty by virtue of lethal injection, no? So siya ay papatayin sa pamamagitan ng lethal injection. Sabi ni Leo Echegaray, ang death penalty through lethal injection ay cruel, degrading, hindi makatao daw, no? Ano ang sabi ng Supreme Court? Mali si Leo Echegaray. The death penalty is not cruel, it is not degrading, it is not inhuman. In fact, sabi ng Supreme Court, in fact, ito ang pinakamatao na paraan kung paano patayin ang isang tao. Kasi injection lang ang gagawin doon. Under the death penalty by virtue of lethal injection, there is the first substance na i-inject sa tao na yan, known as sodium. Basta tatlong substances yon. Yung first substance is nakalimutan ko na yan. Basta tatlong substances yon. May sodium thiopentothal, tapos may pancuronium bromide, no? Tapos may basta tatlong substances yon. First substance is to induce sleep o pakalmahin ang isang tao. Yung next substance is to paralyze the muscle. And the third substance is to stop the beating of the heart. No? So, tatlong substances yun na magkasunod na i-inject. So, according to the Supreme Court, it is the most humane way, pinakamatao na way in order to kill a person. So, let's go to an issue. Okay? Let's go to an issue kung for us to determine if what happened in the case of death penalty, is it totally scraped or was it just suspended? So, according to the Supreme Court, in a case entitled People of the Philippines versus Munoz, ang nangyari dito is this happened at Pangasinan, San Carlos City, Pangasinan, wherein may mga private armies, yung mga bodyguards, nakapatay sila ng sibilyan. Nahuli ang mga private armies na ito at basta to cut the story short, ang naging issue dito ay what happened in the death penalty? Was it suspended or abolished? No? Ang sabi ng Supreme Court, the Supreme Court held that Article 3, Section 19, Paragraph 1 of the Constitution did not abolish death penalty. It only suspended it. Okay? Kaya, ang death penalty ay pwedeng ibalik kung kagustuhan ng ating Kongreso. So, inulit ko ang death penalty ay hindi siya na-abolish. Sinuspend lang siya at pwedeng ibalik anytime kung kagustuhan ng ating Congress. So let's go to the section 20 or of the Article 3 of the 1987 Constitution, which states that no person shall be imprisoned for debt or non-payment of poll tax. Ibig sabihin, hindi pwedeng ikulong ang isang tao dahil sa hindi niya pagbayad ng utang o sedula, no? Kaya sige, mag-utang lang kayo. Hindi naman kayo ikukulong diyan, no? But kailangan na alamin natin na utang yan, hindi siya tax, hindi siya fine. Kaya pwede bang ikulong ang isang tao kung hindi siya nagbayad ng tax? Yes. Pwede ba siyang ikulong kung hindi siya nagbayad ng fine? Yes. Kasi ang nakalagay sa ating constitution is debt. Utang lang yun, no? So, let's go to the case of Criminology versus Court of Appeals. Si Mr. Criminology ay kinasuhan ng libel sa Regional Trial Court. So, napatunayan na siya ay guilty. Sabi ni judge, ito ang gawin natin, Criminology. Meron kang fine, no? Meron kang fine. Kung hindi mo isettle o kung hindi ka magbabayad sa fine na yan, i-convert natin yan into term of imprisonment. At ang tawag natin doon ay subsidiary imprisonment in case of insolvency. I repeat, ang tawag natin dyan ay subsidiary imprisonment in case of insolvency. Yan ay ikukulong natin ang tao na yan kung sakaling hindi siya magbabayad ng fine. Ang depensa naman ni Criminology, ay nako, tignan ninyo ang section 20, article 3 of the Constitution. Nakalagay doon na no person shall be imprisoned for debt. Hindi pwedeng ikulong ang isang tao dahil hindi siya nagbayad ng kanyang utang. No? Ano ang sabi ng Supreme Court? Debt ang pinag-uusapan doon. It does not include fine. No? Kaya kung sakaling hindi siya nakapagbayad ng fine, siya ikukulong. At inulit ko, under Criminal Law 1, ang tawag natin dyan ay subsidiary penalty or imprisonment in case of insolvency. So, let's go to section 21 of the Constitution. Ang tawag natin dito ay right against double jeopardy. Okay? Right against double jeopardy. Ang essence lang naman ng right against double jeopardy ay hindi pwedeng managot ang isang tao dalawa o higit sa dalawang beses sa isang crime na kanyang ginawa. So I repeat, ang essence ng double jeopardy ay hindi pwedeng managot ang isang tao dalawa o higit sa dalawang beses dahil lang sa isang crime na kanyang ginawa. Kaya kung na-acquit o na-convict o napatunayan nagkasala ang tao na yan sa isang kaso, hindi na pwedeng buhayin na naman ang kaso na yun. No? So, ito ang requisites ng double jeopardy. Kailan ba natin i-claim na may double jeopardy? So, pwede natin i-claim na may double jeopardy kung lahat ng mga requisites na ito ay present. First, may valid complaint or information. Uy, mali yun. May valid complaint or information. Dapat yun, hindi off. No? Valid complaint or information. Next, such complaint was filed in a court of competent jurisdiction. Okay? Yung complaint o information na yan na isampa sa isang court na may jurisdiction. Tapos, katulad ng trial in absentia, dapat may arraignment. Tinanong siya kung guilty or not guilty. And the accused was convicted na-convict yung akusado or acquitted, or the case was dismissed or otherwise terminated without his consent. Ibig sabihin, hindi kagustuhan ng akusado na terminate ang kaso. O siya ay na-convict, siya ay na-acquit. No? Hindi na pwedeng buhayin na naman yon. Kasi kung bubuhayin yung kaso na yan, ang tawag natin dyan, ay madidismiss yan dahil na-violate ang kanyang right against double jeopardy. So I repeat, the essence of double jeopardy is no person shall suffer twice or more for a single crime that he had committed. So the best case na pwedeng makapag-explain sa double jeopardy ay yung People of the Philippines versus Relova. No? People of the Philippines versus Relova. This happened at Batangas City. Si Relova, nagnakaw siya ng electricity. So, ang nangyari doon, inulit ko, si Relova ay nagnakaw ng electricity. So, dalawang pwedeng criminal case na pwedeng isang palaban sa kanya. Dalawang basis, no? Kasi yung pagnanakaw sa electricity, punishable yan sa Revised Penal Code. Ang ginawa ng City Council ng Batangas, kinopya nila ang provision ng Revised Penal Code na yan at linagay nila sa ordinance. Okay, linagay nila sa ordinance. Kaya ang pagnanakaw ng electricity ay punishable sa ordinance at the same time punishable sa Revised Penal Code. Okay. Nung nahuli siya na nagnakaw ng electricity, kinasuhan siya ng violation of ordinance. Okay? So, yun. Nung afterwards ay dinismiss yung kaso. Okay? Kahit di ko na i-explain ang manner of dismissal kasi complicated na situation yon. Basta dinismiss. No? Ang ginawa ni Fiscal, kinasuhan niya na naman si Relova ng pagnanakaw ng electricity at ang kanyang basis yung Revised Penal Code. So, pwede ba yun? Hindi pwede yun. Hindi na pwede yun because it already violates the right against double jeopardy of Mr. Relova. Nung na-dismiss ang kanyang kaso ng pagnanakaw ng electricity at ang kinaso sa kanya ay violation ng ordinance at na-dismiss, totally dismiss na yon. Hindi pwedeng bubuhayin na naman at sasabihin ng fiscal na ang basis ko ngayon ay hindi na yung ordinance, yung Revised Penal Code. Parehas lang din naman. Ang ginawa lang naman ng City Council ng Batangas ay kinopya nila kung ano ang meron sa Revised Penal Code. Yan din ang nasa ordinance. Okay? So, let's go to section 22. The last section. So, no ex post facto law or bill of attainder shall be enacted. So, ano bang ibig sabihin ng ex post facto law? It literally means the law before the fact. No? An ex post facto law is the law before the fact. It is the law that makes an act punishable in a manner that it is not punishable when committed. No? Like for example, the act of spreading computer virus noong 1990s. Di ba? May Filipino noon na nag-scatter ng computer virus noong 1990s. Nung hinuli siya, there is no specific law punishing that act. No? There is no specific law punishing that act. After several years, nandyan yung specific law punishing for the act of deliberately scattering computer virus. Pwede bang mananagot ang tao na yon? Hindi. Because at the time that it was committed, it was not yet a criminal act. No? So this is consistent with the characteristic of criminal law, which is the prospective characteristic of criminal law, which states that the criminal law must be applied in the future and it cannot be applied in the past. No? Yan ang ibig sabihin ng ex post facto law. So ano ang characteristics ng ex post facto law? It refers to criminal matters. It is retroactive in application. It works to the prejudice of the accused. Kaya, paano kung ang bagong batas ay favorable sa accused? Pwede bang i-apply sa accused yun? Yes. No, it is not ex post facto law. Because the ex post facto law is the one that is disadvantageous, is the one that will prejudice the accused. Ano naman ang Bill of Attainder? Ito yung batas na ginagawa ng ating Congress na automatic may penalty kahit na kung walang trial that was conducted. No? So, Bill of Attainder is a legislative act that inflicts punishment without trial. So, it is unconstitutional. That's it. So, ladies and gentlemen, we already finished the discussion of the Philippine Constitution. So, we will be scheduling a recitation for this purpose, no? So perhaps the recitation will be next week or this week, no? I will be informing you.